believe that access to timely justice is a basic human right. COVID-19 is threatening that access across the globe. Disruption has meant enormous backlogs, and courts have struggled to remain functional, often using tools and solutions not designed for the complexities of today's case files. Digital Evidence Center is a proven solution in virtual, in-court, and hybrid hearings, eliminating delays and backlogs by empowering courts to facilitate more efficient hearings than those using existing solutions. Customers have reported up to 50% less hearings required to conclude a case, reduced hearing times, and zero pandemic-related backlogs. Digital Evidence Center enables all parties in a case to share documentary and multimedia exhibits and evidence, both effortlessly and securely, and tools to support pro se litigants ensure better access to justice for all. Easily create automatically paginated, indexed, and fully searchable case bundles. Upload and present all media types direct from your case file, including video and audio evidence. Prepare, share, and present with confidence, whether virtually or in court, knowing that all parties are working from a single version of the case documents. To get your litigation back on track, visit tr.com/evidence sharing.
Welcome everyone to the final webinar in the NACM Mid-Year Educational Series. My name is Kathy Griffin. I'm President-elect on the NACM board. I've had the privilege this year of working with our educational consultant, Jude Del Priore, to put together the sessions for both our mid-year and our annual conferences. I hope you enjoy the session, and I want to thank our partners at NASG for the presentation. Thank you.
Thank you, Kathy. Thanks again for that brief sponsorship video from Thomson Reuters. I'd like to thank you for joining the last of NACM's 2021 Mid-Year Educational Series. Today's session is from NACM's core, Purposes of Courts, The Challenges. Today's presenters will be Jeff Schrade, Todd Brower, and Gabe Goltz. COVID-19 pandemic has significantly disrupted nearly every aspect of American life, but courts have been particularly impacted. By their nature, courts bring people together on natural ground to resolve disputes. Nevertheless, innovative court leaders have rapidly adapted court processes to administer justice during the pandemic, for example, by allowing parties to meet virtually. While not exactly easy, pandemic adjustments to court processes have been mostly technical, but adaptive challenges unrelated to COVID-19 have also emerged. This interactive session will explore the fundamental purposes and responsibilities of courts, examining how court leaders have used these basic tenets to guide them through the pandemic and can apply them to emerging challenges. One of our speakers is Jeff Schrade. He's the Educational Services Division Director for the Arizona Supreme Court Administrative Offices of the Courts. In his executive level position, Jeff provides leadership on statewide judicial branch education initiatives and innovatives that have made Arizona one of the leaders among states in judicial education. Prior to joining the court, Jeff was with the Arizona Bar Foundation, where he served in a variety of positions. He has also been a communications special projects coordinator for the Children's Action Alliance and also worked in government relations at United Way of Greater Tucson. Gabe Goltz is currently the program manager of the Education Programs Unit in the Arizona Administrative Office of the Courts Education Services Division, assisting in the administration of judicial officer training, judicial staff training, and judicial branch leadership development, holding a Bachelor of Arts in Political Science from Northern Arizona and a Master's of Arts in the same from the University of Colorado Boulder. Since joining the AOC in December of 2005 as an educational specialist, the Court Leadership Institute, Gabe has developed and taught courses in areas including adult education, a variety of diversity-related topics, constitutional law and history, the purpose and responsibility of courts, law and literature, and ethics in film. And last but not least is Todd Brower. He's the Judicial Education Director of the Williams Institute on Sexual Orientation Law and Public Policy at the UCLA School of Law. He's a professor of constitutional law at Western State College of Law in California, the director of the Institute of Global Law and Policy there. He also has an LLM from Yale Law School and a JD from Stanford Law School and an AB from Princeton University. A lot of letters. And was a Fulbright Scholar in France. Professor Brower served in the California Judicial Council Access and Fairness Advisory Committee, and is the author of various law-related articles, research studies, and publications on the treatment of lesbian, gay, bisexual, and transgender persons in the courts in the UK, California, and New Jersey. He has worked with the courts of several nations in Europe, Africa, North and South America, and many U.S. states and federal agencies on judicial education programs and with internal and national judicial organizations. He is the current president-elect of the National Association of State Judicial Educators. Today's session is 1 hour long. There will be question and answer time allotted at the end of the presentation. Please enter your questions in the Q&A box so they can be asked during that time. NACOM members, please join us for the second hour in the separate link that was sent out for additional question and answer and the release of NACOM's Core Champion Certificate Program. And with that, I'll turn it over to Gabe.
Thank you so much, Jeff, and thank you so much, NACOM members and attendees. We're so happy to be here with you this morning and hope that we can go on kind of a fun journey through some really important topics. The purposes and responsibilities of courts through changing times. So just to kind of get us going here, if I could get a show of hands for how many of you know who Ernie Friesen is. That's a joke, but I want to know how many of you actually maybe like at your seats raised your hands just to participate. Ernie Friesen, for those of you that don't know Professor Friesen, he is maybe best described as the godfather of court administration. He came of age in an era, and we're talking late 50s, early 60s, where court administration consisted of the judge and an office or court full of clerks. Court administration didn't exist as a profession on its own, court administration. And so Ernie and his colleagues kind of invented it, realized that the effective running of courts wasn't just about judges, that there was somebody that needed to be in a leadership position, overseeing, running, leading the administration of the courts, all the things that the judge doesn't do, essentially. So that's Professor Friesen. If you travel far and wide through the ranks of NACOM or court administration in the United States and even in the world, you're going to encounter him if you haven't already. Just a couple of facets of his career I wanted to share with you really quickly. He was the founding dean of the National Judicial College in Reno. He was an assistant U.S. Attorney General from 1965 to 1967. He was the director of the United States Administrative Office of the Courts from 67 to 70. And then perhaps most to the point here today, he was the founder of the Institute for Court Management in 1970. So you can see how so many aspects of his career intertwine with our own today in court administration. So early in his career as a court administrator, he brought together a team of his fellow court administrators, and they thought, you know what we need to do? We need to develop the purposes of courts. Now, I teach a 2.5-day class on the purposes of courts for the Institute for Court Management. And in that class, we explore all kinds of topics, but we start with the purposes of courts. What are the purposes of courts? Now, when I ask classes that, you know, we'll sometimes get questions like to decide cases, but why do we have purposes of courts? Why did they spend so much time developing these and then continuing to teach them to this day? I want to challenge you to think about the purposes of courts something like a mission statement. It's why we exist. We need to know that so we know if we're meeting our purposes, and more importantly, or perhaps as importantly, when maybe other branches are encroaching upon those purposes. So it's vital for us to know what these purposes are. I encourage the class participants to take these 8 purposes and share them with their colleagues, to put them up in their office. I can't turn around my laptop right now and show you, but I do have the purposes up on my wall. And there's something that helped guide me in my day-to-day work. And I think they probably do the same for you, even if you're not aware of them yet. So he developed these 8 purposes, and they've really stood the test of time and help inform us as court administrators, as judicial branch personnel, where we need to be going and what we need to be doing better and not doing. So let's dive right into those 8 purposes now. The first is to do individual justice in individual cases. Now, this may almost seem like a no-brainer. Yes, of course, that's what we do. We do justice. But when I have a class face-to-face, I say, so can y'all help me understand what justice is? What's the definition of justice? Of course, there's silence. And I said, well, if I really was going to force it on you, I bet I would get about 30 or 40 different answers to what justice means. So when we think about it from the standpoint of a purpose of court to do individual justice in individual cases, the focus here really ends up being on the individual. That every individual's case is unique in some way, that they have an individual right, an individual expectation to getting that from the court. So we really need to focus on that individual. And that's when we make that transition into procedural justice. Now, I'm not going to teach a class today on procedural justice. If it's a topic you're not aware of, I encourage you to go seek it out. There's wonderful work on it. And it's so critical to us in this branch. But it's the idea that we have set up a system such that every individual gets to be heard, gets their day in court, even though so often now we don't actually have that day in court, and has that expectation and that feeling that they did in fact get their individual justice. So number one, to do individual justice in individual cases. Number two is to appear to do individual justice in individual cases. Now, I promise you 3, 4, 5, 6, 7, and 8 aren't just extended formulations of number one. But I want to focus very carefully on this to appear to do individual or to do justice in individual cases. We think of the question, what is so important about appearances? I'm sure many of you are guided by a code of conduct that includes something about appearances, appearing to be ethical, appearing to uphold the integrity of the judiciary. People say, well, what's so important about that? Well, those of us that have been in the system long enough know what's so important about that is maintaining public trust and confidence. That's the fuel that really drives the judicial branch and drives our place in society. People need to have faith and confidence and trust that what's going on in courts and what's being done by courts is justice, is the right thing, is what they expect us to be doing. And that's often because it appears like it is. There's an old maxim in politics you may have heard before. And that's that if you're explaining in politics, you're already losing. If you have to explain why what you're doing is justice, you're probably already in trouble. Now, that isn't to say sometimes the public doesn't understand what we're doing or how it's justice or the procedures and whatnot that courts follow. But the idea is that if something doesn't look like it's justice, we already have a problem because people will begin to question, gosh, what is going on there? So we really need to focus so importantly on maintaining that. Now, we do it in obviously very simple ways, like having a certain decorum within the courtroom. We want court buildings to look nice and in nice repair. And that's a kind of topic that we talked about elsewhere today. But this idea of appearances is so important. The public needs to know what we're doing is providing justice in individual cases. And by and large, we need to look like we're doing that. Number 3, to provide a forum for the resolution of legal disputes. Now, this, of course, is an ancient purpose. It's a purpose that existed before there were, in fact, written laws. The idea that people have disputes. Now, it may have been in ancient times where you might have had the elders gathering around a fire and deciding what to do about a conflict within a tribe or a family or a community. Well, courts stepped in and filled that void. Now, I always ask classes, what are the alternatives to courts providing a forum for the resolution of legal disputes? And I get lovely answers like, well, we can go to ADR, for example, or private mediation or things of that nature. And that's all true, but I remind them there are, in fact, other alternatives to solving disputes. Go to the Old West. How did they, I'm here in Arizona, how did they solve disputes here in Arizona back in the day? Well, maybe it was a duel where two individuals would fight or have a shootout. There are obviously lots of ways to solve disputes, but courts fill a special role, a place to do it dignified, safely, where people have to agree to a set of rules. Now, I'm sure you've seen some courtroom interactions where it's clear that individuals don't necessarily agree with some of the rules that are occurring in a case or in court. But it's this idea that we're coming together in a civilized forum, and courts fill that place in a very special and unique way that they don't get anywhere else. And then you think about all the other ways where maybe it includes a jury, where once again, we have members of a community coming together to agree on justice. But courts provide that place. So number 3 is to provide a forum for the resolution of legal disputes. Number 4 is my personal favorite. During my introduction, my bio from Jeff, he mentioned con law. I'm a total con law nerd. That's probably why I work in the judicial branch. I had no idea that there were jobs like mine in the judicial branch when I graduated college with my very useful political science degrees. So here I am because I'm a con law nerd. So some of you may recognize that individual there. It's not Henry Fonda, for those of you that have seen the movie, but it's a gentleman named Clarence Earl Gideon. Mr. Gideon was arrested and filed a writ for certiorari to the U.S. Supreme Court eventually, handwritten. It's a really interesting document if you've never seen it. He handwrote it on prison stationery. And what the case ultimately ended up in is the incorporation of the right to counsel in criminal cases to the states. So now when we provide attorneys, public defenders in most cases for litigants in criminal cases, that's because of Clarence Earl Gideon's case. So we think about this purpose of court, to protect individuals against the arbitrary use of government power. Now, I always find kind of a juicy irony here. That means that individuals, citizens or not, go to courts, which are in fact part of the government, for protection against the government. That highlights the very unique role that courts play. Even though we are obviously part of government and all that comes with that, the good stewardship of taxpayer dollars and whatnot, and being held publicly accountable, and in many cases having our proceedings open to scrutiny and our documents available to the public, we are part of the government. Of course we are. And yet when somebody has a dispute with the government or needs protection, as it were, from the government, where do they go? They go to courts. So courts play this, again, very special role that the other two branches don't. And in fact, in many cases, or in some cases at least, in Arizona, it happens from time to time, where parts of the government have disputes with each other, perhaps the legislature and the governor. And again, where do those disputes get resolved? In courts. Courts are that place where if a government has potentially overreached its authority, harmed a citizen in some way, or the citizen feels that way, they go to court. And again, the juiciest Supreme Court cases almost always involve that, at least historically. Number 4, protect individuals against the arbitrary use of government power. Number 5, provide a formal record of legal status. Now, in our professional lives, I'm sure we've all been to meetings, perhaps more than we would like, where you sit down and you start talking and you think to yourself, hadn't we already discussed this and come to a resolution already? Why are we doing this again? And gosh, maybe you've done it 3 or 4 times where you've been in a meeting and thought, we've done this 3 or 4 times before, haven't we? So we all know the value of a record, minutes, right? Committee minutes, some record of what the committee has done. Well, courts provide this in a much larger and more important sense by providing finality to individuals. Sometimes they are litigants in a case, but not always. Think about all the ways that we do this. Name changes, dissolutions, adoptions, driving privileges, voting privileges, the ability to own a firearm. All of these ways where courts are the kind of record keeper, the final record keeper in many important legal ways. Think of the turmoil that would result if there wasn't a place for an individual to go to get this final record. All the ways that your life would be challenging if somebody didn't know you had gotten divorced or won a case or lost a case. All of these certain kinds of life actions that are so important to us. Courts are that formal record keeper. It's a vitally important, we might think of it as sort of benign at times, but when it's your life, your freedom, your rights on the line, your ability to function in life, it's mightily important. In Arizona, we have elected clerks of court who tend to be, each of our 15 counties in Arizona have an elected clerk of court, and that's generally who is responsible for number 5, providing a formal record of legal status. Number 6, to deter criminal behavior. Now, 6, 7, and 8, in terms of the purposes, are purposes that we share with other branches of government, and you're going to see that. Deterring criminal behavior obviously isn't the sole purpose and responsibilities of courts, but we play a very important role. Now, if you think about deterring criminal behavior, it's not just the existence of a punishment that does that. Knowing that, yes, if you do X and are convicted of it, found out, whatever, that you're going to suffer a certain consequence. That alone doesn't deter criminal behavior. It's knowing that that punishment is real, is a reality. Now, as a quick example, there is a judge from Hawaii named Steve Alm, A-L-M. If you don't know Judge Alm, he started a really amazing and fascinating program that has spread nationwide. Now, in Hawaii, they call it HOPE, H-O-P-E, HOPE probation. In Arizona, we developed a system called SAFE, Project SAFE. But the idea is that when probationers violate their probation, there should be swift consequences, immediate consequences, not long drawn out period where maybe in 2 or 3 months you might suffer some consequences for perhaps violating a term of your probation. The idea is that people learn not to do something when the consequences are swift. So in courts, in the context of court administration, it's the idea of a speedy trial. That's what it is, knowing that there's going to be accountability for your transgressions, and it's going to be swift accountability. So when we think about things like case processing and how important that is, that's absolutely deterring criminal behavior, our 6th purpose. Now, we're fortunate enough to have a moment to hear from Professor Friesen himself.
Time is a justice measure. So when you're keeping track of when something happened and the next event and the next event, and you see things put off over and over again in a court, you're really looking at the loss of justice in the system. Justice
delayed is justice denied. Now, again, we get back to, we could debate endlessly about, well, what is justice? It's case processing. It's time to disposition numbers. Justice delayed is justice denied. Number 7, to rehabilitate persons convicted of crimes. Now, again, this isn't the judicial branch's sole area, but again, it's something important that we do. Now, you may have heard judges say, I'm not a social worker. Kind of in the mid-90s, early to mid-90s, we began to see in the judicial branch the rise of specialty courts or therapeutic jurisprudence, therapeutic courts, you may have heard them called. This is something that the judicial branch has taken on because the public has increasingly expected of it, that we play an important role. Of course, sentencing, different kinds of creative sentencing plays a role in that. And probation officers in Arizona. Now, I realize not in all states do probation officers reside in the judicial branch, but in Arizona they do, and they play an important role in the rehabilitation of persons convicted of crime. And then finally, the 8th purpose, to separate those convicted of crimes from society. Now, no, this isn't a picture of MASH in Maricopa County, which is where I live and work, the largest county here in Arizona. For a long time, we had what was called Tent City. You've probably heard about it. It doesn't exist anymore, but prisoners were housed in old army tents. So we have separation of those convicted of crimes from society. Again, we play a shared role in that. That's a partnership we have, for example, with corrections professionals, which are usually in the executive branch. But playing that role as a court, saying, look, you individual need to be taken out of society for whatever the reasons. Now, of course, we do that in other contexts, not in the context of a criminal case, but when we think about commitment, individuals who pose a danger to themselves or to others. Courts play an important role in that as well. To say, look, as society, we're speaking up to say this individual needs to be set apart and hopefully rehabilitated or healed from whatever it is that ails them. So those are the 8 purposes of courts that have stood the test of time. Now, if we had more time, we could say, what are some other purposes? And my colleague Kent Batty, who used to work down in Pima County here in Arizona, he wrote a really amazing article a few years ago in, I think it was the NACM magazine, where he made the argument for 3 new purposes of courts. I would encourage you to seek that out and engage Kent's ideas. I won't spoil them for you, but he does make a really forceful argument for 3 additional purposes. So those are the 8 purposes of courts as traditionally defined by Ernie Friesen and NACM. So I'm going to turn it over to my colleague, Jeff Schrade, to do kind of a deeper dive into the way some of these purposes have been challenged. Jeff?
Thanks, Gabe. You know, I feel really fortunate in teaching with Gabe and Todd today because they are just giants. I mean, I don't know 2 better thinkers and teachers. And so my goal today is going to be to queue up some questions. There will be more questions than there will be answers in my section of the presentation because I'm coming in between Todd and Gabe. This is really going to queue up a lot of good, interesting information that I think Todd is going to share with some answers on how we can apply the purposes and responsibilities of courts. So we're in a time of great challenge. That is apparent. We've been going through a pandemic for over the last year that has just really been unprecedented in our history. And it's raised a number of challenges. Today, I'm not going to focus on those challenges of the pandemic as much as I'm going to focus on the challenges beyond the pandemic, because we're starting to see, thankfully, the end of the pandemic here with growing numbers of vaccinations, masks coming off all over the place, and a general increasing level of comfort in resuming activities that we could not undertake during the pandemic, including meeting in person for conferences. I know the July NACM conference is coming up, and everyone's really excited about getting together in San Diego for that program. Now, this is kind of a pandemic-related challenge. Many of our hearings went online. We went to remote hearings because people could not gather during the pandemic. These remote hearings became ubiquitous. You've probably seen the audio and video of this clip right here, where a practicing attorney had a filter on, I guess, that a kid or grandkid had set up and couldn't figure out how to take it off. And it resulted in just a real funny clip. But these, you know, we're not in the business of creating funny clips, right? We're in the business of providing justice, as Gabe said. And so these remote hearings raise some issues. And are these remote hearings going away just because our ability to gather in person is resuming? I don't think so. We had remote hearings before the pandemic, and we'll have remote hearings after the pandemic, possibly and quite probably to a much greater extent. Another thing that has been a challenge that is going to last beyond the pandemic here is the backlog of evictions and foreclosures. We've had a moratorium on these court processes for the most part over the entire duration of the pandemic. And the result has been kind of like plate tectonics. The friction and the number of these cases potentially building up in the system, we don't know because many of them haven't been filed, is just enormous. And so we are expecting, I think the CDC moratorium on evictions expires at the end of next month. And so we'll really see how this plays out. This raises a lot of challenges for the judicial branch and puts us in the position of frankly, really putting a lot of people out onto the streets, and also really potentially affecting that view of the courts doing justice. It's not going to seem like a very friendly type of justice that's taking place, even though it's adhering to the letter of the law. This is to the point where John Oliver, who runs an HBO program, has kind of skewered this. So let's hear what he has to say about this potential.
It's true. The coronavirus crisis could also soon turn into a full-blown homelessness crisis. And it's hard to even fathom something already so bad transforming into something else so appalling. And it says something about the utter absurdity of what's about to happen, that this is how some eviction hearings will be taking place.
Starting with tomorrow's docket, Judge Lopez will start hearing eviction cases, either in the court using webcams with the defendant and the plaintiff in separate rooms, over Zoom, or even on the phone.
What are you doing? You know, it might be worth thinking twice about what you're taking part in if you're throwing people out of their homes via Zoom, a platform you're only using because it's not safe for people to leave their homes.
So we're in a tough spot, as John Oliver points out, and this is a real friction. This is a real concern of the public and the public's perception of the courts doing justice and their confidence that we are doing the right thing in the administration of justice. You know, also emerging from the pandemic is a kind of resurgence of concern and about racism, about systemic racism, not just in the court system, but beyond and throughout our society. It's something that, frankly, America has really tried to do to address throughout our history, but is something that is not solved at this point. And so we can see how this touches this idea of systemic racism touches our justice system and our law enforcement system in every aspect. We can harken back to the arbitrary use of government power. I think there are concerns not just about the arbitrary use of government power, but the unequal use of government power and the proportionate use of government power that are all kind of encapsulated in these concerns about systemic racism and our kind of inability to solve that issue in the justice system and in our society as a larger whole. We just saw the trial of the officer Derek Chauvkin that was involved in the George Floyd murder earlier in the year. This was a high-profile case. Think about the timeline that this kind of ran on. We had the public seeing video of the actual situation. We had protests and riots as a result of the injustice that was perceived in that situation. And that all happened within a matter of weeks. It wasn't until just a couple of weeks ago, months after this situation had happened, that we had a formal court proceeding that kind of offered that finality that Gabe talked about in the legal record purpose of the courts. And so in between, that really affected the public's perception of how the courts were operating, the speed at which they were operating, the ability of our justice system to provide justice and to provide timely justice. Did we appear to do justice? Well, I can tell you, I work in the same office as Gabe. We were anticipating the release of the verdict in the Chauvkin case, and the office was very tense. The individuals in the office were very tense. The feeling on the street was very intense. Everyone was hanging on this verdict that was being released from a single court. And I think that if that verdict was something different than it was, we might have seen another public eruption. And so this is something that is carrying forth beyond the pandemic. And I think that'll really be something that courts will need to consider in their planning, not necessarily in their judicial decisions, but in the planning around how court processes take place, how rapidly they take place, and the public's expectations and the public results of some of the decisions that are made in courts. Let's talk about another high-profile situation. This was the January 6th riot at the U.S. Capitol, where I guess everyone knows the story. A group of folks forcefully broke into the U.S. Capitol to stop a democratic process, which was the ceremonial certification of the presidential ballots and the presidential election, to stop that process from taking place. This was not the first time that a rowdy mob tried to stop a democratic process. Look back to the 2000 election, and there was something called the Brooks Brothers riot, where a group of folks gained entry into a place where ballots were being counted, and the folks who were counting the ballots couldn't, in Miami-Dade County, could not continue counting the ballots and complete that process before the court-ordered deadline to complete it. So they just stopped. This goes back to purpose number 3, and providing a civilized forum to regulate disputes. When folks feel like the courts cannot solve the disputes in a civilized manner, i.e. an election and the results of an election, then they take other means. Gabe talked about the Wild West and how these disputes in the Wild West were solved by a duel or a gunfight. Well, this is one of the modern equivalents of it, I fear. And as this, as the trusting confidence in the judiciary to mediate and resolve these disputes erodes, we might see more and more of this happening. And so, this is something that's very tricky. What can we do as a judicial branch? I don't know that I have the answer, the complete answer to that. But I know it's not something that we can just sit back and say, well, this is a legislative and executive branch issue. This is an executive and legislative branch problem. This is a problem of all the institutions, the democratic institutions, including the judiciary, and one that we'll have to address. Think about how your court has maybe responded to some of the protests and riots and some of the things that have been happening in the streets during the pandemic. Did your courthouse look like a bunker for a while? I know my courthouse did in the center of Phoenix with the Arizona Supreme Court. We had barbed wire around it. We had walls and stanchions in anticipation that folks were going to try to damage property or gain access to the building. We're so careful about how our courthouses look and how they promote this idea of justice and fairness. And how does that perception change when our public court spaces are under lockdown and have walls and fences and barbed wire around them? Again, just really kind of affects that public trust and confidence in the judicial system. And I'll kind of lead into Todd's section with this cartoon right here. We are in the business of judging. We are in the business of providing justice, but that public trust and confidence gives us the ability to do our jobs, to administer justice and provide justice in our communities. So while we are doing that, it's always good to remember that the public is silently judging us the entire time as well. With that, I will hand it off to Todd to talk a little bit about some of the ways that we might be able to address these big questions.
So thank you very much, Jeff. And also thank you to Gabe and to NACM for inviting me. So I'd like to talk a little bit more about the public trust and confidence aspect of it, which, as both Gabe and Jeff mentioned, is really part of this idea of perception. And as Gabe talked about in the second of the purposes of courts, the idea that you need to appear to do justice. Well, as we know, right, this is an important part of trust and confidence. So I have a question for you. I'm a law professor. What can I say? I start with questions. When most court users think about their court experience, at least 50% of them are unhappy because somebody has to lose the case and somebody has to win. Is that true or false? So ordinarily we'd have a poll, but in the interest of time and because it's a webinar, just think to yourself what your answer is. So the truth is, the answer is that this is false, right? In fact, as I'm sure you know, the best predictors of trust and confidence in courts is this thing called procedural fairness, which is really divided into two different things: procedural equity, about neutrality, efforts to be fair, politeness, respect for the voice and rights of individuals, etc. And then efficiency, procedural efficiency, which is a process that's efficient, that is easily understood. And then in this last part, I want to focus on this part of it, and where decision makers consider relevant evidence. Now, I think for those of us that work in courts and think about courts, when we say relevant evidence, we mean evidence according to the relevance rules in the evidence code. But in fact, I don't think that's what that's talking about. Yes, it is to some degree, of course, but it's also talking about the perception among court users, the people in the courtroom when a case is happening, that in fact the judge and that the court system itself is taking in the best, useful, most relevant information in the non-legal sense. And of course, the two are not always the same, right? What can be legally relevant can be different than what a person perceives as an important piece of evidence in a situation. And that underlines the idea that when we're talking about public trust and confidence and procedural fairness, we're talking about not only objective reality, but in some sense, the perception of that reality in a very real sense, actually. And so that when we think about the four things, and I'm not going to go into this to a large degree because of two reasons. One is, I'm sure you've seen these before: respect, voice, neutrality, and trust. But secondly, there is a whole set of materials which are available to you which has this information as well as some other information. But each of these things, when you look at respect, voice, neutrality, and trust, they're not only talking about objective things that courts and people who run courts and manage courts and who are in courts, working in courts, can do, but also the perception that those actions have on the public. All right. So this is one of those things that the materials has for you. I have a little self-assessment take home, as I said. So this is my red pen. I'm not using it to grade you, but I am in the process of grading my students. But there is a little self-assessment for you to think about the issues. What are the features of your courts that are designed to ensure procedural fairness? And in the materials, there's some answers. And I guess what I want you to think about, if you decide to do this, is to think about not only those things which create the objective fairness, but also the perception of fairness and reality, because the perception, of course, is important. So why does this matter? Well, is one of the things that Jeff alluded to is this piece of data that we have, which is when litigants believe the court process was fair, they're more likely to comply with court orders and to follow the law. And that's part of this idea of dispute resolution and the validity of the dispute resolution, or perceived validity of the dispute resolution. And that goes into the question of fairness, right? And the perception that you're being treated fairly. And so I have a clip for you. It's, you may have seen this clip before. It's an experiment on monkeys. Each monkey has a task and will receive a reward once they complete the task. The task is to give the rock to the scientist. You need to know that monkeys like cucumber, but that they absolutely love grapes. So here's the clip.
Getting grape, and you will see what happens. So she gives a rock to us, that's the task. And we give her a piece of cucumber and she eats it. The other one needs to give a rock to us. And that's what she does. And she gets a grape. And she eats it. The other one sees that. She gives a rock to us now, gets again cucumber.
So I have a laugh track. What can I say? It goes along with my video.
She tests the rock now against the wall. She needs to give it to us. And she gets cucumber again.
So obviously, this clip can stand for a number of things, but what I want to use it for is this idea that when we're not being treated fairly, that's a basic kind of part of us as humans, and even obviously animals that are not human. And that's an important part of the trust and confidence, the perception of whether or not, in fact, the process, the rewards, etc., are fair. Excuse me. And that is why this information, I think, is so important. This information comes from the National Center's State of the Courts in 2018, which is the last time they had actually good data on this. And they asked people, the court system is fair and impartial, and do you agree or disagree, or the court system provides equal justice for all? And what we see, and the numbers themselves are not the important part, but what is important is the pattern here, which is that white folks agreed with those ideas of the courts as being fair and equal justice, much more so than African Americans, Black people. And that's an important distinction in how people perceive courts. There is another question that the National Center didn't ask, but in fact, other people have asked, and it goes along with the idea of how do people perceive the courts in terms of their fairness to the majority versus their fairness towards members who are not of a majority. And that regardless of who we're talking about, people believe that the courts are fairer or more fair to people in the majority, whatever that majority is in that locality, than they are to members of a minority there. And so that we see this in terms of not only people divided by race in this particular example, but also in terms of people's perceptions of the fairness of courts towards minorities generally. And that the National Center has an additional issue, speaking more to the issues that are involved in fairness, that is a procedural fairness. In general, judges in your state courts reflect the values of our communities and understand the challenges facing the people who appear in their courtrooms. And then sort of the negative version of that. And we see the same pattern. That is to say, white folks have a much higher perception that in fact courts and judges are better able to see and actually reflect the individuals in front of them in the courtroom than do African Americans or Hispanic Latinos. And that in fact, the National Center, again, didn't state this, but in fact, there's a lot of data that say this exact same pattern holds true when we're talking about LGBT people, when we're talking about people with disabilities, when we're talking about people who are below the poverty line, when we're talking about people who are self-represented litigants. So that, in other words, the distinction between what the majority believes and their perceptions of the court and what a minority, however you're going to define minority, is important, because in fact, when we think about trust and confidence, we need to think about not only trust and confidence in terms of people generally, but specific parts of our communities where the courts take place. So then, all right, these are the things that Jeff mentioned, right? What I think is important, in addition to what he said, is that all of these things have led to sort of a loss of confidence in governmental institutions generally, including the courts. And that's why I think procedural fairness in the post-pandemic, whatever the new normal we're going to call it, those kinds of things are incredibly important, because we're not starting from the same place I think we were starting from a year ago. I think we're starting from a deficit. And so that when we think about public trust and confidence in the courts, we need to be thinking about the impact that has had on not only the individuals and the specific things that Jeff mentioned, but also the institution as an institution. And for those of us that work in courts, I think that's incredibly important. All right. So in the materials, you'll see two other sort of self-assessments. That is to say, there's a self-assessment about what do you think about how do the public access your courts? What about the interaction between the court staff and the public, understanding the court proceedings, what things are available there, ensuring voice, etc. And that you can think about it in a number of dimensions, should you be so inclined to do this. That is to say, when, from the first time that someone accesses the courts, when they're going in and they have to deal with security, if they can physically get to the courts, and if they can't, of course, that's an issue. Or for that matter, the first time they receive a jury summons, right? Which is in fact the way in which most people actually access the court, is through their jury service. So think about that through the system that exists. Where do people access it? As I said, jury service is actually the most common way in which this happens, but traffic and small claims encounter service is in fact where more people access the courts than as litigants or as witnesses in the various proceedings that we think of in terms of litigation. And then who? Once again, right, self-represented litigants, people from various diverse racial, ethnic, cultural communities, limited English proficiency. What does access look like for them? So that's in the materials if you decide to do that. Then I have one last thing. Once again, it's a clip.
This is an awareness test. How many passes does the team in white make?
Go!
The answer is 13. But did you see the moonwalking bear?
And I think that's an important point, right? It's easy to get caught up in the day-to-day of what we do, and particularly the sort of getting back to whatever normal will be for us, that we sometimes miss these bigger pictures and the bigger kinds of issues that hopefully in this class today we've been talking about, right? So I really appreciate the opportunity to spend time with you and to teach with my colleagues, Jeff and Gabe, and for NACOM for inviting us. So I think at this point, we're going to turn it over for questions. Our contact information is here. I can't speak for Jeff and Gabe, but I'm going to do it anyway. I think they would be okay with the idea of talking afterwards, and that's why we have the information there. For sure, I would be. So I'll leave it open for questions. I think, Jeff, that's back to you.
Thank you, gentlemen. Very good presentation. And I have seen it before, so I actually looked for the moonwalking. I thought it was a monkey again, but it was a bear. So thank you. There was a question that first came out asking about the name of the author who suggested the 3 additional purposes of courts. That's been answered through the chat and a link to some of that article. So there is some more resources there, folks, if you were looking for those additional. I didn't know if you had any addition that you wanted to add to that, Gabe, or not.
And I want to thank our participant, Kenneth, for pointing to another article that deals with additional purposes in response to Kent's article. I would really encourage you to go read. I can only speak for Kent's because I haven't read the other one, but I'm sure both are very good, and kind of a nice ongoing way to engage that, because it's an ongoing discussion. And you know, these 8 purposes aren't new. So the question becomes, of course, as leaders, constantly engaging and saying, well, maybe the purposes of courts are changing as society's expectations changes, or as new things come up like pandemics or racial strife, that maybe our purposes might change. And just simply sitting on those 8 forever and not recognizing that, I think, is a disservice to the branch and sort of a shortchanging of your leadership abilities. So definitely go engage those ideas. And I hope more people will write more articles about the purposes, because some of us are nerds and don't like to read books on the beach. We like to read NACOM articles.
Well, speaking on the purposes, we do have one question that came through that says, I'm confused by the description on purpose number 3. Ernie Friesen and his 1970 video describes number 3 as providing a final resolution of disputes rather than a forum for the resolution of disputes. Any thoughts on that?
Yeah, thank you for that. I'm sorry I don't have anything terribly insightful to say, other than that I'm just not familiar with that particular formulation. So I'm gonna have to do a little research. I don't know if that was intentionally changed, or if it was one of those errors that somewhere along the line somebody didn't correct a typo and it became the new purpose. I probably have to take a moment to think about the kind of philosophical ramifications of the difference between a final resolution versus a forum for resolution.
And you have one without the other. I'd argue no. So I think it's part and parcel. It's just the way of getting to that formal resolution. You know, a gunfight in Tombstone is another way of getting to that formal resolution.
And final, I may add.
In the case of the Clantons, yes, final.
We had another one that came through of what challenges do you think homegrown extremists and sovereign citizens pose to purposes?
Just to get the conversation going, I mean, I think one of the challenges, and obviously that umbrella encompasses a lot, so I wouldn't necessarily want to, you know, lump all viewpoints under that umbrella, but at least some of the sovereign citizen movements that I'm familiar with, you know, they have just a fundamentally different understanding of what's in the Constitution and kind of the tradition of American jurisprudence and courts and such. So, I mean, it is a challenge. You know, those individuals often have a much different expectation about how courts, how government should operate. And so, it's a fundamental challenge. Just on a training challenge, we get that question all the time of providing judges training for dealing with individuals whose viewpoints maybe are, again, very outside what we would consider sort of the normal understanding of how courts and how laws operate. So it's definitely a big challenge. Gosh, that would be an interesting conversation with maybe a sovereign citizen individual or somebody more familiar with that about how, what do they think the purpose of courts are? I'm sure some of them are pretty standard, like providing, again, that place, providing justice, that place to get to justice. But I'm guessing other things are probably a little bit different for them.
Well, I also think, to step back from sovereign citizen just a bit, I think one of the issues that's a challenge for us, and it's alluded to in the chat in this comment, is that the kind of shared values and shared understandings and shared sort of common views, in this case, the Constitution and the role of courts, maybe not as shared as we once thought, or maybe those are appearing in ways where we ignored them before, or they didn't show up before. Social media, for example, has amplified voices that might otherwise have been only heard by a few folks. So I think that is a big challenge for courts when sort of basic common viewpoints are less common or are becoming factionalized. I think that's very difficult for people to agree. Well, at least we agree on this. I don't know that the this is the same thing as it once was.
We do have another question that I think we have a little time left. Would you all agree we're living in a low point with faith in American justice systems, given the heavy injection of politics in courts these days? How do we combat this and restore confidence?
Yeah, I'm sorry to change in there. And, Gabe and I work in the same office and at times have shared a wall. And so we're talking about this, and we've talked about this frequently over the last several years. I would contend that there is more confidence in American institutions, including the court, than there really has ever been, in American history. I mean, we have to kind of take a look at where we've come from. More people are going to court now to resolve their disputes than ever. We've got more courts and more people working for courts than ever. And, think back to some of the things. I mean, when we first established the U.S. Supreme Court, there was an issue with the Chief Justice running for the governorship in New York, John Jay, and think about today how we have the separation of powers and kind of a much more defined institution in the Supreme Court, in the judicial system. I mean, before Marbury and Madison, I mean, we didn't really have much of a definition of our court system in the first place and what it was really supposed to do for our democracy. So, we don't have the 101st Airborne going into high schools to reintegrate. We don't have a civil war. We've had very dark times in our history. And, the promise of the Constitution wasn't to create a perfect union. It was to create a more perfect union. And I think we're constantly endeavoring to create that more perfect union. And the courts are an important important player in defining and bringing about that change to get to a more perfect union. So I don't think it's a lost. I don't think it's game over, and I don't think it's even the worse off we've been in our history.
I think we had perfect timing there, Jeff. Appreciate it. We're going to wrap up here for the first session. This will be posted on the NACOM website. So those that one of the resources that will be posted on the website. Thank you, gentlemen, for a great presentation today. They will carry over a few of them to the second session for any other questions, and we'll expand on the core champion. So you all have a great day, and all the NACOM members, please join us in the second session. And if you are not a NACOM member, please consider joining and get a discount to see us in person in July. So thank you again. Have a great day.